Welcome to Module 8. You found a buyer, negotiated terms that work for both of you, and verified their credit qualifies them for the deal. Now it's time to close and get paid. In this module, I'm going to show you how the closing process works, who should prepare your documents, and what critical provisions need to be included to protect you. Let's talk about who should prepare your loan documents. You have two options, and each has trade-offs. Option 1, title companies. Title companies are easier to use and more convenient. They handle seller financing transactions regularly. They know the process. They can get documents prepared quickly. And they're generally less expensive than attorneys. But here's what you need to understand. Title company documents are designed to protect the title company, not you. Their primary concern is making sure the title work is clean and their title insurance is protected. The loan documents they prepare are often more generic and may not have all the protections you'd want if you end up in litigation with a borrower. Option 2, attorneys who specialize in foreclosure, private lending, and creditors' rights. Attorneys are more expensive than title companies, but they're more thorough. An attorney who specializes in private lending and creditors' rights will draft documents specifically designed to protect you. They understand what provisions matter if you end up in a dispute with a borrower. They know how to structure documents that hold up in court. And here's a huge added bonus. If a borrower defaults, that same attorney can handle the foreclosure for you. They already know your documents, they understand the case, and they can move forward quickly. So which should you use? That depends on your situation and risk tolerance. Title companies are fine for straightforward deals with strong buyers. But if you want maximum protection, especially on larger loans, use an attorney. Regardless of which option you choose, always charge the buyer for the cost of the loan documents. This should be part of their closing costs, not an expense you absorb. Include this in your $500 loan fee or as a separate line item. Even if you use an attorney to draft your loan documents, you should always close through a title company. Here's why. The title company will conduct a title search to make sure there are no unexpected liens, judgments, or other issues with the property. They'll issue a title commitment that shows you exactly what's on title before you close. Review this title commitment carefully. Look at every item. If you see anything you don't understand, an easement, a lien, a restriction, ask your title agent to explain it. Understand exactly what you're dealing with before you close. The buyer should pay for a lender's title policy. This is title insurance that protects your interest as the lender. If there's a title defect that affects your lien, the title insurance covers it. And here's a key feature. The lender's title policy is transferable to all future owners of the loan until it's paid off. When you sell the note to me, that title insurance transfers. This makes your note more valuable. The HUD statement, the closing statement, will verify that the buyer made their down payment. This is critical documentation if you sell the note. Now let me cover a couple of provisions you may want to include in your loan documents. Whether you use a title company or an attorney, you might want to think about making sure these are included. First, specify that this is vacant land. This is important because regulations are different for vacant land versus improved property. Second, if the buyer is using an LLC or company, require a personal guarantee. The individual behind the LLC or company should personally guarantee the loan. This prevents them from walking away from an LLC with no assets. Third, include a power of sale clause. This allows the lender to force the sale of the property and foreclose in case the buyer defaults. Fourth, specify that notices can be sent electronically. If permitted in the state, this allows you to communicate via email rather than certified mail or personal service for everything. Fifth, do not include a prepayment penalty. The buyer can pay off the loan early without penalty. This is a borrower-friendly provision that removes a common objection. Sixth, specify no escrow for taxes. The buyer pays property taxes directly. You'll check online to verify they're current. But include a provision that if the buyer fails to pay taxes, you can add escrow and the buyer will pay the increased servicing fees. These 6 provisions protect you while keeping the loan structure simple and reasonable. Let me address double closings briefly because some of you may be wholesalers. Double closings with seller financing are more complicated than regular double closings. There are more moving parts and more potential for confusion. Be very clear with the title company about the structure. They need to understand that you're selling a property to a buyer with seller financing, then immediately selling that note to a note buyer. The note buyer must buy the loan from you, not the original seller. The chain has to be clear. Original seller to you, you to the buyer with financing, you to the note buyer. You may need same-day transactional funding. Some note buyers, including me, can provide this, but arrange it ahead of time, not day of closing. Double closings require careful coordination. Make sure everyone understands the structure before the closing. Remember, you can use title companies for convenience, but understand their documents protect them, not you. Attorneys are more expensive, but provide better protection and can handle foreclosures. Always charge the buyer for document costs. Close through a title company with a lender's title policy. Make sure your documents include the 6 critical provisions we discussed. In the next module, we'll talk about document management and why you need professional servicing. Let's keep going.